So the 8th Circuit Court of Appeals just ruled on the ATF's new rule on frames and receivers. So let's talk about this. But real quick before we jump into this video, if you think the ATF's rules on frames and receivers is clearly unconstitutional, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I will leave a link to them down below if you're interested. As I mentioned in the intro, in this video, we'll be discussing the Gun Owners of America and the 17-state lawsuit, which was against the ATF and their new rule on frames and receivers. The case we'll be talking about in this video is called Morehouse versus the ATF. This case recently had oral arguments take place before a 3-judge panel in the 8th Circuit, and since then, we have been essentially waiting for the 8th Circuit to issue their decision. And recently, we just got the decision from the 8th Circuit, and I'm going to be honest with you guys, it's not good. GOA, along with multiple states, tried to get the 8th Circuit to recognize how the new ATF rule will in fact be an infringement on the Second Amendment, and that it should be struck down because it violates the Administrative Procedures Act and also the Second Amendment, and it's a violation of constitutional rights. For those interested, the 17 states which joined this case and joined GOA, those states are Arizona, West Virginia, Alaska, Arkansas, Idaho, Indiana, Kansas, Kentucky, Louisiana, Missouri, Montana, Nebraska, Oklahoma, South Carolina, Texas, Utah, and Wyoming. Well, the 8th Circuit ruled unanimously that a preliminary injunction should not be granted because plaintiffs cannot show irreparable harms caused by the ATF and that frames and receivers rule. Now, if you're not aware of what this lawsuit entails, this is a lawsuit against the ATF because of that frames and receivers rule. This new rule by the ATF is essentially a restriction on the sale of 80%ers. Under this new rule, 80%ers are treated to actually be firearms. This new rule went into the regulatory definition of a firearm and changed the definition through a web of references so that now 80%ers are included in the definition of what a firearm is. Since 80%ers are now considered to actually be firearms, they are subject to serialization requirements and also background checks. Recently, we saw that the ATF also went out and submitted an open letter to the public stating that even unfinished polymer frames on their own fall under the rule's restrictions. Through that letter, the ATF claims that they consider solo incomplete frames to be firearms, even if it's not sold with other items like a jig, drill bit, or even instructions. This is contrary to the actual statements by the ATF in various lawsuits, including another case we're going to talk about, which is the Vanderstock case, and that is in a Texas federal district court. It's also going to be heard by the 5th Circuit, and it's relevant also for what the 8th Circuit did in their decision here in this Morehouse case. But generally, that's a gist of what the final rule does, and that's what's being challenged by GOA and the 17 states in the Morehouse lawsuit. This case was filed in a North Dakota district court, and GOA requested that the district court judge grant a motion for a preliminary injunction to stop the ATF from enforcing the new rule. However, on review, the district court judge, Judge Peter Wilt, found that under Bruin and other concepts, an injunction was not warranted in this case. In his decision, the judge stated that the court believes the ATF's response to the Second Amendment concerns brought up during the notice and comment period to the notice of proposed rulemaking was sufficient. As noted in the final rule, concerns regarding constitutionality of the proposed rule were raised by multiple commenters. The ATF appropriately responded by indicating its belief that the proposed rule was consistent with Second Amendment jurisprudence at the time of the final rule was drafted, and explained why. It is difficult to fathom what more the ATF could have said in response at the time, as it could not have predicted the future development in the law. Here he's referencing that when this original rule was first proposed, the Bruin decision was not in place. Then the Supreme Court issued their Bruin decision, and the judge here believes that the ATF appropriately responded to the comments in the proposed rule, and that they didn't need to take in consideration the Supreme Court's recent decision in Bruin. Another concerning thing the judge did was he tried to cabin Bruin as if it only impacts proper cause standards in concealed carry permits. Now, after that denial of the preliminary injunction, GOA appealed the decision up to the 8th Circuit. The 8th Circuit 3-judge panel was Judges Stephen Colleton, Michael Melloy, and then Raymond Gruender. On review, the 3 judges unanimously agreed that the lower court was correct in denying the injunction and that the ATF's frames and receivers rule should not be halted. In their decision, the 8th Circuit primarily focused on the fact that they believe the plaintiffs here cannot show that the ATF rule will cause irreparable harm. Now, to get a preliminary injunction, a party must show 4 main things. First, a likelihood of success on the merits. Second, irreparable harm in absence of the preliminary relief. 3, that the balance of the equities tips in the individual's favor. And 4, that an injunction is in the public's best interest. Now, in reaching their decision, the 8th Circuit found that GOA and the 17 states could not show irreparable harm. The 8th Circuit stated that, "We find the plaintiffs have failed to show they will suffer irreparable harm absent a preliminary injunction. We need not address the likelihood of success on the merits. This is especially true when, as this case here, we are not the only ones addressing the merits of these arguments." One of the key things that the 8th Circuit is doing here in this specific decision is they are avoiding looking at the likelihood of success on the merits factor, which really is the biggest factor for an injunction analysis. Instead, they are punting this issue because the 5th Circuit is also going to be reviewing this very ATF rule on frames and receivers in the Vanderstock case. To me, this decision of the 8th Circuit just simply smells like a huge punt by the 8th Circuit, that they didn't want to fully address this ATF rule, that they didn't want to take on this issue, so they're doing anything and everything they can to get out of this decision. And really, this is only a 10-page opinion. So for something being so important like this, the 8th Circuit took multiple months, I think it was up to 6 months, to issue a 10-page opinion where they just are simply completely punting the case. What the 8th Circuit did here is they looked narrowly at irreparable harm, and they ultimately found that they are not going to do any of the heavy lifting in regards to a likelihood of success on the merits. Instead, they're going to leave that to the 5th Circuit. The court goes on to state in their opinion that the plaintiffs assert they will suffer Second Amendment harm absent a preliminary injunction. We conclude that the plaintiffs have alleged a mere possibility of irreparable harm before a decision on the merits can be rendered. They have failed to show that irreparable injury is likely in the absence of an injunction. Our conclusion at this early stage of litigation does not speak to the merits of a Second Amendment claim later in this litigation. Again, the section here is the 8th Circuit saying that they see no constitutional harm suffered right here and now. That doesn't mean that they don't believe that there won't be harm down the road. Simply, they're just going to punt this issue. They're not saying that the plaintiffs here, GOA in the 17 states, won't win on their Second Amendment claims, that they won't win on the merits of the lawsuit, but that the 8th Circuit doesn't see anything wrong right now, so they're going to send this back down to the lower court. If you wanted an example of how a court will completely kick the can down the road and not want to address an issue, this is the perfect brief that you can look at. They then go on to say that they're not going to address the other factors for a preliminary injunction because they say that there is no irreparable harm, that they're not going to address the likelihood of success on the merits, that is maybe something that the 5th Circuit will look at, that they're not going to look at right now. And so they're going to dismiss this case, or they're going to deny the request for an injunction because they believe there is no irreparable harm. This could be because of the Supreme Court recently granting the stay in the Vanderstock case, the 5th Circuit case that went all the way up to the Supreme Court for a stay. They ruled in favor of the ATF. At least they granted the stay. So that's currently in place. So it could have been all of a sudden the 8th Circuit felt that they didn't need to do a full decision. Maybe they just saw the out because of the Supreme Court, so they decided to issue this weak opinion. So really not great news, but there is still that 5th Circuit Vanderstock decision, which is going to make its way through the 5th Circuit. I anticipate that that will be a good outcome out of the 5th Circuit. But again, we're going to have to keep our eyes on that. But right now, it seems like there are some federal courts who still do not want to take up any of these cases. They don't want to address the Second Amendment. They don't want to address ATF overreach. And really, it's only a limited number of circuit courts right now, like the 5th Circuit, who are willing to actually strike down these ATF rules. But if we get any more information, of course, I will let you all know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.